The Florida Rental Agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of Florida. What is a rental agreement? A rental agreement or a lease is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, the landlord should provide the tenant with a general disclaimer about the radon gas danger if the rented apartment is located in a building that has been found to have levels of radon gas that exceed federal and state guidelines. Another information the landlord should provide in a written form before the parties enter into the agreement is the names and business addresses of the people who own and are authorized to manage the rental unit. In addition, the landlord should provide a written disclosure of how the security deposit funds will be kept, while the tenant is renting the property, as well as general information about security deposits and how they work in Florida. Security deposits. In the state of Florida, there is no statutory maximum for the security deposit. Landlords have 15 days to return the deposit if the tenant is due a full refund. If landlord withholds any amount of the deposit for damages caused by the tenant, they have 30 days to notify the tenant via certified mail. If the landlord fails to return the deposit, the tenant can receive the court costs and attorney's fees. Landlord Access. In the state of Florida, the landlord should send the tenant a 12-hour notice before entering the apartment to inspect it, make necessary repairs, etc., unless otherwise agreed upon. Only emergency cases allow the landlord not to send such a notice before entry. Termination of agreement. For termination of a year-to-year tenancy, a 60-day notice should be sent by either of the parties. For termination of a month-to-month tenancy, a 15-day notice should be sent by either landlord or tenant. For termination of a week-to-week lease, a 7-day notice is needed. Notice periods for non-payment and non-compliance. If the tenant fails to pay rent, the landlord should send at least a 3-day notice to pay or quit, excluding Saturday, Sunday, and legal holidays. If the tenant breaches other provisions of the lease, at least a 7-day notice should be sent to either remedy the violation or vacate the premises.